Welcome to the Spiggle Law Podcast, where we talk about cutting-edge employment law issues in the news for those people who have been fired or afraid that they might be. Today, I am thrilled to be joined by a senior attorney in my office, Louse Ryder, who has years and years of experience. I will not go through her entire bio, but it's very impressive. She has done a lot of work with federal sector cases, so we're going to be talking about that today. But before we get started, just a little bit of legalese. This is not intended to be legal advice for listeners, nor does it create an attorney-client relationship with the firm. If you want either of those things, then you got it. You should go hire a lawyer. So with that, Louse, welcome.
Thank you for having me.
So let's just start off for people who may not know and talk a little bit about the difference between federal sector employee and private sector employees.
So as an employment attorney, when we refer to the private sector, we're referring to private employers, such as companies, businesses that are not the government. So for instance, public sector, we would generally be referring to either government employers, state employers, local employers, or federal employers. And what we're going to be talking about the most today is the federal sector employment law, because it is distinct from most other categories. There are a lot of administrative requirements that you have to go through, and there's a lot of specific rules that apply. With regards to the federal sector, you have to exhaust your administrative remedies. And one thing that makes the federal sector very distinct from most private sector is the fact that federal sector employees are not at-will employees, because the Constitution prohibits the government from taking away something of value from an employee without due process of law. A government employee is deemed to have a property interest in their position, and therefore there are certain protections which prevent the federal government from unreasonably taking away someone's job or taking up certain other actions against them. So because of that, there is a very distinct, there's a distinct administrative agency called the Merit Systems Protection Board that you can appeal to an adverse action to. You can also bring equal employment opportunity claims. So there's several different administrative agencies that handle federal sector employees.
Yeah, no, I mean, that's great. And I think it can be confusing for folks. It can be confusing for lawyers because in some respects, a lot of the same law applies, right? If it's a discrimination case, we're talking about Title VII, which is true for federal sector or private sector employees. And if you have to ask the question, am I a federal sector employee? You're probably not, right? You're a federal sector employee if you work for the federal government. And some of these protections, although we're not going to get into it specifically today, do apply to state level jobs too, where you have, as you talked about, a due process, right? But those laws vary by state. So we're going to be focusing on federal sector today. And as you mentioned, there are federal sector employees enjoy more rights than people in the private sector, at least with regard to procedure and dismissal process. And the process is slightly different in that if you're in the private sector, you file with the EEOC. If you're in, federal sector, you go through the EEO process, which again is similar, but on a separate track. So it does get a little bit confusing. Before we start, are there, for like government contractors, are there areas where it is, you can be either or is it you have to be working for the federal government?
So yes, federal contractors are generally governed by can be governed by the same EEO procedures as federal employees. So the protections offered to federal employees with regards to equal employment opportunity, or EEO, are available as well to government contractors.
Got it. And so let's just start, let's say you're working for a federal agency or you're a government contractor and you're under the EEO process and you believe that you're being discriminated against or you're pregnant and they're discriminating against you, any kind of discrimination issue. how does one start that process? What's the first leg? How does somebody initiate that process in federal sector?
If you feel that you're being discriminated against in the federal sector, the first important thing is that you have to raise any claim of discrimination within 45 days. So you have to go through the administrative process before you go to court. And this administrative process, the first step would be to file an EEO pre-complaint with your agency's Equal Employment Opportunity Office. So every agency has such an office, and what you need to do is you have to initiate that contact within 45 days of the adverse action that you believe is discriminatory or retaliatory. So you would go to your agency's EEO office, and you can either send them an email or go in person and request the forms or speak to someone. I always recommend trying to make sure that you have a written record, because there are certainly circumstances where, especially if you're going to the EEO office on the 45th day, maybe someone doesn't write down if you just had a verbal conversation, and then they'll try to use the later date where you filed the forms, despite the fact that you have to initiate contact with the EEO office, meaning it can include that verbal conversation or an email you send. You don't have to file the form by that 45th day. That being said, it's always better to err on the side of caution and try to get things in sooner rather than later. So I would certainly recommend that.
Yeah, I think that, that's another difference between private sector and federal sector. There are different deadlines, which is really important. If you're in the private sector, depending on your state, you have either 180 days, or like most states in the DMV, you have 300 days to file your charge with the EEOC. And so I think it's crucial for folks to know that if you're a federal employee, that's a 45-day window, which is clearly pretty short.
And it also is something you should keep in mind if you're experiencing continued discrimination, you still have to meet that 45 days. You can with regards to each adverse action. And now that's a term of art for certain acts against you. A hostile work environment or harassment that doesn't rise to the level of an adverse action, that would be continuous, deemed continuous. But if you experience, for instance, a demotion, a loss of pay, a suspension, or a termination, each one of those has to be raised within the 45 days. And you want to make sure you can always amend a claim to include subsequent acts, but you don't want to miss that deadline.
And what was it? I can't remember. Did you say the name of the form that you have to file? Is there a particular name?
Well, every agency generally has their own form, but once you reach out to the EEO office and say that you believe that you want to file a complaint of discrimination, that is initiating contact, and usually what they'll do is they will send you a form for completion, and they'll generally ask you to describe the bases of discrimination. And what we mean by bases is if you believe you're being discriminated against because of your race, sex, disability, age, or because of your prior EEO activity, which can include requesting reasonable accommodation for a disability or some other protected category.
Right. And so, one of the things as we kind of go out through this process, and get your thoughts on, when it's best to be working with counsel or go hire an attorney. Obviously it's, as attorneys, we like it sooner rather than later for you to hire someone. But could you hire someone, let's say, because obviously, if you are, you're not a lawyer, you don't do this sort of work, it may be difficult in some circumstances. I mean, some adverse employment actions are pretty clear, right? Don't need a law degree to figure it out. If somebody says, hey, we've got, too many women around here, and so we're going to fire you. Well, that's pretty darn clear. But there are areas, particularly for, as you mentioned, hostile work environment, where it can be more difficult as a legal matter to determine whether you have have a case, have something that's addressable. Could you hire a lawyer just to kind of help walk you through that process and get the filing done right?
Absolutely. Now, again, as you mentioned, Tom, I do tend to think that the safest bet is to have an attorney from as early on as possible. And part of the reason for that is because if you forget to click off a potential bases, that could raise issues later on, potentially. Or similarly, if you do not outline certain claims, there could be an argument that they were not exhausted. So it's always safer. However, the pre-complaint stage the process is simpler than the later stages in that it tries to cater to pro se employees as well. However, if you are requesting mediation, which is something I highly recommend if possible, I do tend to find that my clients who retain me after mediation have had less of a real chance of settlement during the mediation process than when I attend mediation on behalf with my clients.
So talk to me a little bit about timeline. So let's say they go to the EEO office and right, it's part of their job to help you file this, this charge, right? I mean, like they're supposed to help you walk you through this. Let's say that happens. What is the timeline? What happens? Like I filed the claim, mediation you said is a possibility. Do you like check a box for that? And also, when does that happen? Like if I hire a lawyer, let's say I just go for a lawyer for a consult, and I'm like, I just want you to help me to make sure, I get all the right boxes checked, that, I'm stating things correctly. But that's all I want for right now. And so how much time between that and getting to mediation? And is that the next step? Is it mediation is the next step?
So there are a couple options you have with regards to the pre-complaint stage. And one is simple counseling. And what that means is an opportunity to discuss your claims with the EEO counselor, and the counselor will ask you questions to obtain more information. And I will say that while those conversations are generally supposed to be pretty simple, straightforward, and non-antagonistic, every agency is a little bit different. And I've seen a wide array. I've had many clients who go to those on their own and they do just fine. But occasionally I have had clients who have asked me to be there, and it is a more extensive inquiry than it generally should be. So the counseling meeting will happen regardless of which election you make, but you have the opportunity to elect ADR, which is essentially mediation, or not going through ADR. If you do not elect ADR, the agency has 30 days to complete the counseling and to issue you a notice of right to file a formal EEO complaint. If you do elect ADR, which the ADR is an overarching term for alternative dispute resolution, which includes mediation, arbitration, and other circumstances, not here. And so that's generally the term used, but in this process, what they are referring to is specifically mediation. And mediation differs because what that is a meeting between you and the other side, where there is someone who's supposed to be a neutral party who helps facilitate a dialogue between two parties to try to get the parties to come to an agreement to resolve a matter. So assuming you elect mediation, then the agency will have 90 days to conduct that mediation before they have to issue the notice of right to file a formal EEO complaint.
So you've got some time then. So, if let's say you hire an attorney and, let's say you hire an attorney just to review, the filing with the EEO office. Then you've got, like you said, like up to 90 days, depending when the agency gets their act together to do mediation, before anything else is going to happen, right? Like everything else is just continuing, as normal. And I assume, if you have hired counsel, during that time, there's probably not a lot going on, with your attorney either. Like there's some activity right up front, and correct me if I'm wrong about any of this, but there's some activity right up front where we're learning about the case. We make sure that the EEO the charge is filed correctly, and then there's just kind of a waiting until mediation. Is that how it works?
Yes, that is correct. And I think that one of the most important times to have the attorney is for that mediation if you are looking, almost even more important than the initial forms. Because there are certain ways you can clean up those forms later to a certain extent. It's always better to have a lawyer for each part. But in mediation, if your desire is truly to resolve the matter early on, then I tend to think that it's much easier to get movement if you have an attorney for several reasons. One is that if you are unrepresented by counsel, likely they will not, although this is not always the case, they will not have agency counsel present at the mediation. And so a lot of the time, the agency will conduct a mediation with just the employee and the responsible management official, which is not something they're supposed to do under the EEOC regulations. The management official who attends mediation should not be the responsible management official. And responsible management official is a term of art to really reference the person who you allege is discriminating against you. And it's also referred to as an RMO throughout these proceedings. So I tend to find that it's much easier to get movement if you do not have the RMO present and if you have agency counsel present.
Yeah, that's a great point. And that's, somewhat similar to the private sector EEOC process in that you don't know what you're getting, right? It's a kind of the luck of the draw. You can get some investigators who are very involved and very active. You can draw someone who is, if not openly hostile, at least skeptical about your claims and will almost act like, the opposing party in some instances. And it sounds like the same thing happens on the federal sector side. And it's always, that is one advantage to having an attorney. And I think my recommendation, and I assume yours would be the same. If you walk in, and you're working with that initial EEO officer and he or she is antagonistic, well, then that is a time to get an attorney. You should just know that, right? They are looking at themselves as helping the agency out, not helping you out. And then the same thing is true in the mediation process, which also happens in private sector, that you could have mediations that's just useless because, there's no attorney on the other side. Sometimes the person who they send doesn't have the authority to settle. How awkward would it be to be in a room with just you, the non-attorney mediator, and then the bad guy on the other side trying to get this resolved. So I can see how it would be, you can do it on your own, just like with the EEOC. This process is designed for, as you say, pro se or people who are not represented by counsel, but there is definitely a benefit to having an attorney. Is there any downside to mediation? Like, is there any reason not to request ADR off the bat?
Mediation is always voluntary, so you should keep that in mind. If you do go into a mediation and you find that it's a completely antagonistic situation where you do not have a truly neutral party there, you can elect to end mediation. The main purpose to avoid mediation would be if you are certain that there's nothing to be gained from that, or if you are trying to speed things up as much as possible to get to the next step. For instance, if your goal is to go straight to filing a lawsuit in federal court, there are certain things you can do to speed that up. Obviously, you'd have 90 days with mediation or just 30 days counseling period without it. So you can just, if you can submit your file, request no ADR, and then within 30 days, they have to submit the notice of right to file.
I assume if you do select ADR and it's unsuccessful, then you're just back into the same, like it's all confidential. It's not, you don't lose anything except time. So, if you go through ADR and you're unable to get it resolved, you're not worse off, except for time. You've used some time, but except for the time, your case is not any worse off. You're not going to be damaged.
Exactly. So that's one reason why I generally think mediation is almost always a good thing, because you don't have much to lose. The time I would consider mediation to not be the right approach is when you know that the other side is not going to engage in what you believe to be good faith. And I mean, I've certainly had mediations like that where the RMO has been present, and we have ended mediation because it was very clear that they were not going to offer anything to resolve the matter, and that the RMO was attending the mediation for the purpose of trying to profligate my client. And that's just not an effective mediation, and as it's voluntary, there's no reason to stay in a mediation that you don't believe is going to offer you any potential resolution. That being said, you can get other things from mediation apart from resolving the case. For instance, I always find it helpful to try to get the perspective of the agency, particularly when agency counsel is present, and try to get as much information about their strategy as possible through back and forth, etc.
Yeah, you do learn a lot, even if it's not, there's not a successful, it's almost, free discovery in the sense that you get a sense of what the other side is, going to say, what their position is. So you're right. Even if you don't, get in the case, get a resolution that you want, it can still be productive. Talk to me a little bit about just what the mechanics look like with mediation. Is this in person? Is it virtual? Like how long does it take? Just walk me through, kind of set the scene. So how do I find out about mediation? How do I go to it? What does it look like when I'm there?
So there's definitely different strategies with regards to mediation that different agencies use. The most common traditional mediation is where, and these days most mediation is virtual, although sometimes I do end up in an in-person mediation. And so usually the parties will all call in to virtually, but where we, by video, call into one room. And the most traditional form is that the mediator will give a brief presentation of how things are going to look in the mediation process, and then they will open the floor to the complainant, which that means the person who is filing the EEO complaint, and or his or her representative. Now, generally, I prefer to do these opening presentations on behalf of my client, but it really depends on the client. I have had some clients who would like to do it themselves. Most prefer that I speak on their behalf, but there are definitely circumstances where it can come across better coming from the client. Now, we will make a brief presentation as to our position with regards to the facts potentially, or and then outline our settlement offer. Now, I tend to think that usually the most effective mediation strategy doesn't delve too much into the facts, because inherently the agency is going to deny almost everything that you are asserting, and they will always have their own perspective coming in that is usually coming straight from the responsible management official's mouth. So if you get into too much of this happened, then it really becomes more of an argument, and you don't want to get lawyers arguing if you're trying to settle a case. It's always better to keep things in a conciliatory stature. So that being said, there are certain circumstances where it is important to go into the facts, because if the opposing counsel is not aware of what your facts and allegations are, then and particularly if you have a very strong case, sometimes you do need to go into that. So while most of the time in that initial statement, I try to keep things as brief as possible, thanking the opposing side for coming, and indicating that we're here to try to resolve the matter rather than delving into the facts. I have, in some circumstances, and very recently I had a mediation where I did a deep dive into the facts, and it ended up helping my client by getting her the reasonable accommodation she had thus far been unable to obtain. So after we do the initial presentation, then the agencies will have their opportunity to respond. And hopefully, if things are kept brief, it'll really just be, thank you for coming, and essentially let's move on. And the parties will separate, and the agency will then provide their counter to our settlement offer. Now, the mediator will generally convey these counters back and forth, and after that initial meeting together, we will be separated into two different breakout rooms. And a really good mediator will dive into the details and the legal sufficiency of different claims and try to show the agency counsel where their risk is, and to also speak to us about the potential weaknesses in our claims, because every case has strengths and weaknesses.
How do, and this is a little bit of a broader strategy question, but when you go into mediation, well, let me back up and ask this question first. Before you go to mediation, are you submitting any kind of written statement, or you just go in, like what is the mediator relying on, or are they relying on anything other than just what's happening between the parties at the mediation?
It really depends on the mediator. I have some mediators that will reach out to us in advance. I have requesting a statement. There are some circumstances where I will reach out to them and indicate that we would like to provide a statement if we think that there is something they need to review. It depends on what you think would be helpful, what strategy you prefer to pursue, as well as the mediator's preference.
Got it. So then my second question is, and again, this is more of a broader strategy question, not necessarily specific to mediation, but when you go into mediation, it's always advisable to know what your ask is going to be, or what range you're willing to accept a settlement. So how would you, if somebody comes to your office and they're in the early stages like this, how would you advise somebody on how to figure out what their case is worth, what they should be asking for, what they can reasonably expect?
So what I would do is I would go through the category of damages that they could recover, best case scenario, depending on their claims. And so there are a number of different categories of damages. If, for instance, you were terminated or suspended, you can recover lost wages and benefits. You can you could potentially, if you were successful in all your claims, have an adverse action reversed or rescinded. And you can also recover attorney's fees and compensatory damages, as well as actual damages for a variety of things. For instance, if you had to seek therapy or other medical treatment as a result of the agency's discriminatory acts against you, you can recover any of your out-of-pocket costs. There are unusual categories of damages. Every now and then I'll have a client who has some type of damage that I would not necessarily think about asking. And so I always bring that out. For instance, I had one client who was transferred from one facility to another, and she believed that she was transferred in retaliation for her protected activities. And at her new facility, her parking costs were about $400 a month higher than at the prior facility. And so I always try and see if I can delve into any other potential remedies that could be available that would be outside the standard categories. Well, it's a part of the categories, but unexpected. Now, then I would generally advise my clients as to the compensatory damages they could expect to receive from an administrative judge at the EEOC if they are to prevail on their claims. And what their settlement offer should be something less than full relief. And what that means, full relief is a best case scenario. If you, after extensive litigation, win on every single allegation, and the administrative judge gives you the most that you could be entitled to, that is full relief. And the agency is not going to offer you full relief as a settlement for a claim, because there would be no incentive for them to settle. They have in-house attorneys, so it's not like they're going to have to retain outside counsel like you get in the private sector. And so for them, the calculation would be, if you're asking for full relief, well, why not just go forward? Worst case scenario, we have to give you what you're asking for. Best case scenario, we can make this go away. And so that's why it is essential to come down from the best case scenario in your settlement demand. That being said, it's very much a balancing act. So you want to present a settlement offer that gives you room to come down, because it is a back and forth, but also one that is not going to be so high so as to make the agency counsel unlikely to counter and unlikely to come to the table. And a lot of that is, yes, it depends on the people involved. It depends on the other side's attorneys. There are a lot of different factors. And so we try to walk that line.
When you say compensatory damages, are you primarily talking about emotional distress, or are there other categories?
Compensatory damages represents all the non-quantifiable areas of damage. And what that means is it can be emotional distress. It can be damage to your professional reputation, damage to your career that is, again, non-quantifiable. It can be really everything that you can't put a number value to.
And how, I mean, but obviously for mediation, you want to put some kind of number value on it. How would you go about evaluating that? Like, I think emotional distress is an area that is complicated to a lot of people, because this is stressful, understandably. And I think, though I wish it were otherwise, people have inflated ideas of what emotional distress, damage, what range is reasonable for what has happened in this situation. How would you go about, and again, I know it's guesswork, and the other side's going to have their arguments, but how would you decide what's a reasonable ask for those, compensatory damages?
So it is unfortunate that, in my view, compensatory damages are undervalued. And I think that it is important there's a misconception out there that not everyone believes, but that you can go and file an EEO claim and get this windfall and never have to work again. And that just doesn't happen. It's unfortunately, while the maximum legal compensatory damages available is $300,000, no one ever gets that. And what you're looking at is going to depend both on the types of discriminatory actions taken against you and the amount of compensatory damages you have and the type. Now, judges, and I don't really like this word, but they generally refer to damages as garden variety or non-garden variety. And garden variety, what that really means is just that you didn't have to seek medical treatment as a result. And I don't like the term because it seems to indicate that, oh, this is standard. It minimizes the damage. And even in cases where my client hasn't sought medical treatment, usually these types of discriminatory actions cause serious mental anguish at minimum to my clients that really impacts their lives, their relationships with other people, their careers, their personal mental health, and oftentimes their physical health. And that's where, if we are able to provide proof that as a result of the emotional distress, as a result of the agency's actions in this case, that the client was, for instance, diagnosed with a new mental condition, or had to be put on medication, or had to be treated for a physical or mental injury due to the agency's actions, that would put your case into the non-garden variety realm. And that what that means is essentially that the damages available to you would be higher. So when I advise my clients, I ask them for a lot of details about what their damages are. And so I'll usually ask them about how it's impacted their sleep, their weight, their ability to focus, their personal activities, their relationships with their family, with their friends. And a lot of the time, one of the reasons why I go into things in so much depth is because a lot of the time I don't think we are taught to delve into how we are hurting. We are taught to buck up and move on. And so sometimes people aren't familiar with outlining each of the things that separated out might not seem like a big deal, but put together show a serious impact. So I would delve into what those damages are, find out whether they've received medical treatment due to the damages, and also go into what types of damages are usually awarded in claims that involve similar allegations. So, for instance, claims that involve termination usually have a higher recovery amount than a claim that would involve a hostile work environment that did not result in any adverse action. Now, obviously, that's an overly broad statement in that There are certain circumstances where an employee can show that they can show non-garden variety damages. But usually, if you don't have non-garden variety damages, if you don't have medical documentation of the damage to your mental or physical health, you are almost certainly not going to be able to recover for compensatory damages more than $100,000. Usually it's going to be less than $100,000 in compensatory damages, and very much depending on the claims. And I mean, usually it's much less than I think is appropriate, and most of my clients think is appropriate. I see many cases that involve performance appraisals where the administrative judges have awarded only $2,000 to $3,000. It is unfortunate, but it really varies and depends on how much evidence you can get in to the record as to how harmed you were.
And I think that's another, one other plus factor for hiring an attorney is having somebody who can help draw those details out, because I think it's, as you say, we're difficult, particularly it's happened to you, to really kind of focus in granular detail, which is what you need to do, to paint a picture for the other side of how, emotionally distressful it was to you. And then the other thing is we have certain tools and databases that we have access to, for instance, with our firm, where we can look up that information, right? Like what's kind of, for a case with similar facts, what have other awards been in? It's hard to get that access without an attorney. But even if you're doing it on your own, I think a key point that you mentioned is the max you're going to get. This, if you knock the top out of it, is $300,000. And, whether it's federal sector or private sector, we see a lot of people who, they've seen a case, right? They've seen a case in California or New York where an employee got 7 figures. And those cases are out there, but they're usually almost always under state law. So they're not federal sector to begin with, but even in private sector, there's state law where there are no caps and you can get those kind of damages. So if you're in California or New York or DC, private sector, you can get above that 300,000 range. If you're federal sector, or if you're going under any federal statute, like 300, it's abysmally low. These damages were set in 1991, I believe, and haven't been changed since. So it's unfair. Let's put that on the table. There's no question that these are undervalued. But I think it's important, to your point, when you go into mediation, your opposing counsel is going to laugh you out of the room if if you're like, well, I'm going to get $300,000 in emotional damage. And to your point, like, well, then they're going to say, well, okay, we might as well litigate this then, because they don't care, right? They're getting paid one way or another. They're already on the payroll of the federal government. The federal government doesn't care, so they might as well roll the dice. So I think it's important, whether you're with counsel or not, going into that mediation, having a real, you can aim high, right? It's a game of poker. So you want to, like you said, you want to have some room to come down, but you got to have some reasonable number based on the facts. Again, like you said, that's what the value of an attorney, or working with somebody who can help draw this out, who can help paint the picture for opposing counsel, and who can say, hey, we know the claims with similar facts have gotten these sorts of results. So coming up with that number going into mediation, it's not going to be, as you say, best case scenario. You need to think about what would be beneficial to you right now, right? Because we're going to be talking more about the process, but ballpark, ADR falls through, you go all the way through a trial. How long are we talking?
Part of that depends on just which steps you take. If you want to go straight to federal courts, then you wouldn't necessarily have to go through the EEOC hearing process.
Let's say that. Let's just start with, let's say, the fastest possible route. Get into court. How long before I get, could I get that best case scenario? I'm just asking for round figures, because I want to make the point that you're going to be spending a lot of time to get that extra bit, and you've got to decide if that's worth it. So anyway, I'm sorry. So if you're fastest way possible, when am I getting my result?
Several years, probably.
Right.
So, because essentially if you do want to go to federal court, you can, absolute best case scenario, get through the informal stage 30 to 60 days. Then you could theoretically, within 180 days is how long the agency has for the formal stage. And then you have 30 days after that to either file a hearing request or request a final agency decision. If your goal is to go straight to federal court, you can just ask for the final agency decision. And that is really hard to say. They're supposed to get it done within a certain time period, but sometimes it can take a lot longer, depending. And there are certain agencies that are known for occasionally taking many, many months to get you the final agency decision. And you cannot file in federal court until you receive that.
Yeah. So, I mean, I guess, the practical exercise of mediation is if you could get 60%, 50%, whatever percentage of your best case scenario, like time value of money, right? Like you're going to get that money right now, guaranteed if you settle. And if you don't, you're looking at potentially a years-long process. And the best outcome you can get is whatever it is, the extra 40%. And again, for some people, that's worth it. There's no right or wrong answer. But I got this idea from another attorney, but I thought it was a good one. Like when you're thinking about that money, and everybody, it's a stressful process. You want to be made whole again. So everybody wants more and probably deserves more. But she would ask, her clients, okay, think about what bills you could pay right now with this money. Think about what things you could buy right now with this money and write them down. And before you reject that offer, keep that in mind. And sometimes when people start writing that down, they're like, oh, I could pay off my credit card. I could pay off my car. I could, all these things. I could take a vacation, perhaps, if I bird in the hand right now, or I can take the chance and wait 2 years. Now, sometimes, as you know, you're not going to get that 60%. You're not even going to get that 50%. You may not even get that 20%. You may get something so low ball that, it is worth it, to push forward. I guess the point is when working with an attorney or with your, on your own, coming up with a reasonable ask at mediation, understanding it has to be discounted because the agency doesn't care and they're not going to give you best case scenario. And you've got to think about, okay, what kind of range would I be willing to settle to get this done right now?
In addition, some agencies do have personal caps on how much they're willing to offer at that stage without providing essentially a memorandum and justification and obtaining different other levels of approval. So it is important to keep that in mind. If what you're asking for is above that cap, then then you're unlikely to get it. And at this stage, at the early stage, and unfortunately, you may have to proceed in order to get the agency to come past that, beyond that.
And I guess it would be different too if you're not asking for a monetary award or not a big one. What you're seeking is an accommodation. Does that playing field a little different at mediation?
Absolutely. And I think that mediation can in some ways have the biggest benefit when what a client really needs is something that's non-monetary. For instance, a reassignment, or if it is a reasonable accommodation. And sometimes for instance, the mediation I mentioned earlier, we went to that mediation almost more to get in front of someone who could make a decision on her reasonable accommodation, who could make a difference on that, because my client was not getting any movement. And we went in knowing that they weren't going to settle based on our prior communications, but we came out of the mediation with her being granted her reasonable accommodation request that she needed, granted a transfer, without having to settle her EEO claims. And so there are those other reasons and a lot of things that you can get that are not necessarily monetary. There are also, I tend to find that with regards to federal sector, creative solutions can be essential to resolving some matters. So for instance, there are clients who for instance know that they really can't work anymore and they need to apply for disability retirement. And so we can, during that mediation, negotiate that the agency agree to remove them for medical inability to perform. That will make it much easier for them to get their disability retirement application approved.
Yeah, no, so I think that's important in your mix when you're going in. understanding that the non-monetary and creative asks are much more likely to get resolved at mediation. Not so likely if you are asking for, you're asking for them to write you a check, which you deserve. But it's important to keep that in mind. Just so folks know, and I think most people know and understand, when we talk about accommodation, if you have some kind of disability or something and you need some kind of workplace change, you need to work different hours, you need to work in a different office setting. Like you said, sometimes you need to be transferred. That's what we would consider an accommodation.
One more thing is sometimes if you are dealing with caps, but you do have an opposing counsel who, and by the way, when I say these caps, these aren't legal caps, these are agency policies where an agency has a policy that they won't give more than $15,000 as settlement during the pre-complaint stage unless there are different steps that are gone through. So if you are dealing with a situation like that, but you have an agency counsel who does see the value of settlement in the case, there are different ways you can try to get around that. For instance, an award of sick or annual leave as well. That has a monetary attachment, but can sometimes be more palatable to agencies.
Yeah, absolutely. If ADR falls through, what's the next kind of chapter we're looking at?
Assuming mediation is unsuccessful, the agency will have to issue you a notice of right to file a formal complaint. And that would be the next step in the EEO process, is filing a formal complaint of discrimination. Okay. And that's a bit of a longer process that I think we'll delve into in another episode. But just briefly, it's where the agency will conduct a more thorough investigation into your claims.
Okay, so getting back to mediation, am I understanding correct that punitive damages are not available against the federal government?
That is correct.
So just for folks' education, punitive damages are, as the name suggests, designed to punish the employer. These are available in most private sector cases. Again, these fall under that compensatory damages. So you're bumping up against that $300,000 cap for punitive damages. Again, if you're in a state court or going under a state law where there are no caps, and then you can get those punitive damages, which are designed to punish the company that are in excess of what is offered to make you whole. So let's say you get, $100,000 for lost wages, and for emotional distress, I'm just making up numbers here, you could get another $100,000 in punitive damages. Those are not available against the federal government. So that's another, reason that the claims, tend to be lower. So that can't be part of your calculation. I understand that people are often confused by that because they'll read cases and they're like, oh, well, these punitive damages. But unfortunately, against the federal government, you're not getting those.
That's correct, unfortunately.
So, this has been very helpful in the mediation process. So now we've gone through, we've made some estimation, either working on our own or with counsel, as to what the value of our claim might be. We've tried to come up with a reasonable ask at mediation. We've gone to mediation. It didn't work out. We didn't get what we wanted, and we want to move to the next phase, which we will cover in the next episode. But just briefly, if you can tell us what happens next in the process.
So the agency then has 180 days to conduct an investigation into the claims that you outline in your notice of right to file, where they will ask for documentation from the agency, and they will submit questions to you and to potential witnesses, and you will be able to outline in much more detail all of the facts related to your claims. And it's a great opportunity for you to obtain certain documentation that can help you further down the road.
Yeah, that's great. Well, I look forward to talking with you in the next episode. I think it's an important part of the process, but then been very helpful about, just the beginning process, like how you initiate your claim, and that very important, strategy decision about whether to do mediation and how to approach it. So I appreciate you sharing your knowledge on that. Well, Louise, it's been a pleasure. I look forward to our next episode, and we will learn some more about this process.
Thank you. I hope you have a wonderful rest of the day.
Well, thank you for joining this episode of the Spiggle Law Firm podcast. Look forward to our next episode with Louise, where we will continue to learn about the federal sector litigation process. For those of you who would like some more of this information, You can check us out at the careerrocket.io, where if you give us your email, we will give you a weekly newsletter chock full of great information about how to keep your career on an upward trajectory, as well as the latest and greatest in employment law, and it is all free. So thanks again for joining, and good luck out there in the meantime, guys.